Angela, if I move in a certain position, like right there, I get the sun right in my eyes.
Ooh.
I put the blinds down, but that's as low as they go, and you can see the sun line across my head.
Mm-hmm. And
okay, welcome everybody to Spin Legal tonight.
Yeah.
Okay, so Sam has been doing some checking on our things and updating all of the YouTube videos, and he came across a couple of examples where we put I put Talking Niagara and Spin Legal and vice versa. Okay, only a couple of examples. We'll try to figure them out at some point, but that's a future project, not a now project, right? You know what I mean?
Yeah.
He's been updating all of our stuff, and now if you see that right at the bottom here, just coming up underneath me here, is now a whole load of hashtags.
Hashtags, yeah.
Yeah.
So
which I've added more to Spin Legal to get it going. Okay, so welcome everybody. This is Spin Legal. This is Tuesday night. This is 6 o'clock, and this is our show. So, okay. So if you need to contact Invictus Legal LLP, you can do so at 905-688-5598, or email Angela with angela@weareinvictus.legal, or myself with peter@weareinvictus.legal, and go from there. Okay. Okay. Okay, so what we're talking about tonight is a legal consultation. What happens? Because it's important, I think, that people get through their heads what happens during the entire process. When, you come along, you've got a load of documents. Who's the documents? What happens to documents? What happens about your case? There's a number of various things you need to consider, and I think it's important that people understand what transpires. Okay.
Well, first of all, when you're doing a legal consultation, someone calls up and says, "I want to consult with your office. I have some issues.
I got an issue. Can I come in Thursday at 12?
Yeah, you can come in at 12, but bring everything that you have that's relevant and come and sit down, and then you talk to me briefly over the phone a little bit, just to make sure that it's within our scope and something that we do handle. And then the next thing we do is then we talk to you about what our fee would be for the consultation. A legal consultation, to have a proper legal consultation, requires a fee. I mean, because we're giving up our time, and we're going to be talking to you to at least help you understand a ballpark about where you are.
Yeah.
People think that, well, I thought they were supposed to give free consultations. Okay. Are you a plumber? Do you give free consultations as a plumber?
Actually.
Are you a mechanical consultations for people who come in with engines busted in their cars? Are you are you a nurse or a doctor that you consult with the patient? Do you bill OHIP for it, or do you just not bill OHIP for it?
Yep. Very good questions. And in fact, actually, my plumber doesn't do anything for free, nothing at all. But typically, what will happen is if he's got a thing, he comes in and he says, yeah, okay, that's what I thought it was. Your gizmo here is not connected properly. Then he's gonna say, okay, I can get that fixed for $85 for the parts, and probably $95 for my service, that type of thing.
Yeah, exactly. So these are the facts of what happens when you go and talk to people. You wouldn't tell your plumber, said, "No, I'm not going to pay for your consultation." You wouldn't do that to your mechanic. So why do you want to do that to people who are legal services providers? Yeah.
And in fact, most of the time when you're taking your car to your mechanic, you're doing so on the basis of, hey, it's the part is just broken. Can you fix it? Right.
Yeah.
Now they might say to you, yeah, it's $312, and you go, what? Hey, whoa, why so much? I can get that from recon.com for $112. But you pay. You can make an informed decision at that point, right?
And you could decide, or they can give you alternatives.
Yeah.
It's the same as going to a vet. You take your cat to a vet, and then the vet examines the cat, and they said, okay, there's a couple of things here that you can do. Hey, this is one choice, and it would cost you this much, and there's another choice, it'll cost you this much.
Yeah.
Hey, and they will decide to do that. And even for them to look at your cat, to give them examination, they charge you something.
Yeah. Okay, so so let's look at what happens in a consultation. You come in, you speak to us about your issue. So, hey, I've got just because we were on cars. No, right, yeah, okay. Because we were on cars, I had my mechanic fix the passenger front wheel bearing. And I've only driven it 95 kilometers since then, and it's gone again. I think he did something wrong with it.
Mm-hmm.
Right?
We can talk to you about it and ask you a lot of questions about the history of the problem and your communications with the mechanic, and how much the mechanic charged you. And there should be some kind of report of what the mechanic did, and what they charged you. And then if there's something there that you might want to go to, say, another mechanic and have them check, and then see if there is a legal issue, or whether it's just your car. So, I mean, there's a lot of things. We try to give people some ideas about what to do at that point. We give you options, and then sometimes we'll tell you, like,
well, at the end of the day, it all starts with the prospective client giving their position, whether they're a landlord, a tenant, an ODSP applicant, or so their situation, their story, and expect to tell that for 10 to 15 minutes.
Mm-hmm.
Right.
And they'll story, and then there might be some documents they have.
There's some questions. You probably got some documents, and you probably either brought them in or you sent your documents, right?
Mm-hmm.
And essentially, let me just correct that. Okay, so you brought in or you sent your documents, and at this moment, we probably, if you sent them, we probably had a look at them a couple of days before the consultation, maybe overnight before the consultation, and we've kind of formed an opinion about your case already. We might have some questions about a few of the key documents. Hey, on page 15, you stated whatever. What does this mean? On page 22, the person you want to sue stated whatever. What was meant by this?
Mm-hmm.
Those types of things. If you bring them in, it's the first time we've seen the documentation, we're likely to be spending a few minutes reading it while we're talking. But while you're telling your story, we can read it.
Yep, and we take notes. Okay, sometimes we'll use the AI note taker to have us record the meeting. We ask you in advance, and then we put it into an AI note meeting. So just in case we do get retained and we have your information, and then that way it helps us go forward on whatever action that we are instructed to take.
And by the way, if you bring in documents, we will take a photocopy. Right? We always do take a photocopy.
Okay, and if you have a stick, leave it to us. Sometimes what we will do is we'll have another stick that will give you back your stick at the end of it.
By the way, somebody left a stick with me the other week. It's got no label on it, no anything on it. So if you're a client, and that little black stick is yours, tell me about it, please.
It might be mine.
I don't think it's yours. I think it has client documentation on it, but I'm quite happy to have you look at it.
So I can figure out which client.
Yes, but you see, that's how we want to make sure that if it's yours, we make sure you get it back, right?
Yeah, exactly. Or I put it into a file, then I upload all the stuff that's from the stick onto the computer or onto a Google Drive, and I make sure.
That's typically what I do. Is I put it onto Google Drive. I take it off the stick. Because, hey, thank you for the videos. They're very useful for your case. Take it off the stick and put it into wherever your client documentation is, right? So a lot of that has to go on, because if we're going to actually proceed with your case, we're going to need that documentation.
Mm-hmm.
And so that's true whether you're you're dealing with a paralegal or a lawyer. And typically with lawyer cases, probably where you might give us an inch of documentation. There it goes. If you might give us an inch of documentation, right? You might be giving 20 inches of documentation to a lawyer for some of the things you need to do.
Depends on what you're going for. I've had very documentation for WSIB cases coming in.
Oh, you get them by the box load.
Or for disability cases, and the person's been at it for a long time, and for some reason there's a dispute or a decision they don't like, so I have to work through it and weed through it, and then I have to file an intent to object or do some kind of appeal, and work on that and work through the system on it. So there's a lot of different things that people ask us to do, and it's not rocket science, but this is why when we do, and we'll talk to you about it, we don't tell you how to do your case when you come in for a consultation. We will tell you what rights might be affected by your case, and how we could help you.
Yeah, couple of other things that are associated with this: confidentiality. Everything that you bring into our office is confidential. My mouth is zipped up, never opens big in relation to your material if you don't hire me.
Confidentiality is whether it's just for a consultation or if you give us a full retainer, confidentiality is with us until even past your death.
Yeah, exactly. I can't go blabbing about your case, and in fact,
on the show.
We can talk in brief. We can talk in brief outlines about what has gone on in a case. For example, if we've gone to the small claims court or we've got an LTB order, we can talk in outline about what's gone on there. And in fact, LTB orders are in fact stated law. So the fact that I'm waving an order in front of my hand right today means I've got it about 30 days ahead of everybody else on the planet, right?
Yep.
But everybody else.
We won a case. We got a very today. So these are things that are good, and we collect these, and we try to help people as much as we can. Yeah. So basically, there's two things we owe people who we consult with. One is confidentiality, as we already said, and the other is conflict of interest. If you're telling me you want to sue George Jones, you come in here, your name is Patrick Smith, and you want to sue George Jones, okay? Then 2 days later, somebody by the name of George Jones calls our office and says they want to sue Patrick Smith. We can't even take the call. We can't even accept him to come in and visit us because you've already conflicted it out.
Yeah. In fact, there can be examples of that confidentiality where we could be conflicted out on both sides. For example, you come to see me, and you want to sue the Nissan dealership for something they did on your car, but I've already worked for the Nissan dealership, and but you've given me enough information about you before you revealed it was Nissan that you were working about. So now I'm conflicted out. I can't represent Nissan either.
Mm-hmm. So
Right.
this is where we have to be very careful. That's why we ask you questions. We
Yeah.
take your ID, even for a consultation. We're required to do this because that also helps us determine if there is a conflict. Okay?
And
For example, like there might be 3 different George Jones who come and visit the office, but they're 3 different people. Right? One's 29 years old, one's 45 years old, and the other's 97. So
it's interesting. I had a call from a lady about a year ago now, and I said, okay, so who is the opposing party? And she gave a name. I looked it up in our system, and that sure as heck that name was on our system, on our database. I said, okay, would you happen to have a driving license for this individual? And she said, sure, I have, and started to read off his number, H1234567. And I said, okay, I think we can't help you. Because I'm looking at every digit she's reading off is on the screen here on the screen, and it's like, I can't help you, madam. Sorry.
Yep. And then there's cases where I look it up and I said, okay, what side was I representing? Was I representing the plaintiff side or the defendant side? And was the person who was the contact on our list, was that person our client? If that person was not our client, but maybe somebody that we already sued before in the past, then that's not an issue. We can sue them again. Sometimes 3 times a charm.
And actually, like, for example, there was a landlord that you had represented the tenant against this particular landlord a few years ago, and he came in saying, I want Angela to represent me. And Angela said, well, I can't, but Peter can. And in fact, but the chances of there being
this particular landlord was I was sued this particular landlord, and this landlord sued my client. It was a 2-way suit.
Yeah.
And then I was in court, but then he showed up because it was basically because I handed his butt to him in court. Essentially. So he came by and he wanted us to represent him on some other cases. Yeah. So our firm had taken that up. So I just suggested to
and people. There's no conflict at that point because the original tenant that you represented was never going to be a tenant again.
Yeah, he was tenant anymore. He was gone. Yeah. And the thing is, and he wasn't coming after, and he wasn't asking us to sue our own client.
Yeah, exactly. All right. So, okay, so we would provide a quotation during the course of the consultation. So, for example, well, we've already talked about whether we might take on your case. So we might well then provide you a figure that this is going to cost you X number of dollars. And by the way, that figure is only to open your case. For example, if it's a small claims court case, we're going to give you a quote for writing the claim, serving the claim, and what we might well need to do up to the settlement conference, on the assumption that the defendant doesn't put a defendant's claim in place.
And if they do put in a defendant's claim, we might have to come back and ask for more.
We might have to add a bit more money to defend the defendant's claim.
Yeah.
All right. And the same. So that's the basis upon which we do the consultation. And a large reason why, for example, in small claims court, we do it that way is because in our experience, like 80% of cases are settled within the settlement conference.
Yep. I have a very good track record of settling cases.
Yep.
When we mediate human rights or mediating small claims, different types of cases, I have a track record of settling. Because basically at that point, some cases, you really don't want to go to trial for. For example, if the case is like for $5,000, you don't want to go to trial for it. Or if it's like $10,000 even, like sometimes you can just talk about it and say, okay, let's call it 8 and even.
Yeah,
right?
exactly.
Right? And then that way my client walks away with something and they don't have to pay me to go to trial and all this other stuff to
especially, and there's a lot of paralegals and lawyers will quote a day rate to go to trial, right?
yeah. And there is a day rate that we have, and plus
Yeah.
preparation time rate.
Well, and essentially that day rate includes preparation time, because even if you've got a 4-day trial, believe me, there is still many hours spent before falling asleep, prepping for the next day.
Yeah, and interviewing witnesses, summoning witnesses, serving them. There's a lot of different things that go into setting up a trial and running a trial.
Yeah.
Then the thing is, sometimes trials are multiple days. They could be complex, and we have to be extremely careful with the quotation we provide, so that we have enough to do the trial. We've been burned a couple times before where we give a quote for trial, then we don't get paid for it. And here we are, we're in the place,
Yeah.
We try to tell people you have to pay it up front if you want us to go to trial.
Mm-hmm.
And we also have people sign a paper now saying that I want you to go to trial on this matter. Because it is a client's choice to go forward to trial as opposed to...
And it should be a positive, it should always be a positive choice.
Yeah, a positive choice.
Just because you came out of the settlement conference with a non-decision doesn't mean to say you couldn't offer a new amount.
Yeah, exactly. There's many times I've settled it, like on the courtroom steps, literally.
Yeah. Okay, so in terms of the consultation, we provide a quotation. So that's what we've given you the information about how we provide the quotation. So the other thing to note is that during the course of the consultation, so you walked in, we gave you an amount X, said this is what we can work for, and as you've walked out of our office, you kind of made your mind up and you said, I'm not so sure I want to pay X for this case. I don't think I'm going to do it. You can't show up at court, 3 months later and say, oh, where's Peter Giblett? He was going to represent me.
Yeah, exactly. And the thing is, if it is just a consultation, and generally what we're starting to do now is having people sign a consultation letter if they're coming to us just for the consultation. There are people who do that, and they're very clear about that. And sometimes people will come to us and they'll say, okay, I do have a paralegal, but they want us to go in this direction, and I'm not even sure if it's the best direction for us. And sometimes we will provide an opinion, and that's usually a little bit more money because we have to review what that other paralegal did and what they want you to do, what the suggestion is. Most of the time, that the other person's doing okay, but sometimes you might suggest something on top of that. But we do not try to take over the case at all unless that person independently asks us to.
Okay, so there's a question here. Sorry, you were saying something?
Yeah, because we're not allowed to do that, take a case over like that.
Yeah. Okay, so there's a question about what during a consultation is billable and not billable.
Okay, well, we explain to people, like say if they do decide to retain us, we explain to them what is billable and what's not. Like, for example, drafting a claim is billable. Phone calls might be billable.
Especially if you're going to be on the phone for 45 minutes.
Yeah, like don't call every day and ask us how everything's up, because things start to get built. Okay, because what happens is that it's very frustrating because you're taking time away from somebody else.
Yeah.
who might be that we might be working on. And
Well,
some
it's interesting.
clients, and we have to work on it.
Well, it's interesting today. I had a call this afternoon. I'd forgotten to do something for a client. I did it today. I finished it off and sent it off before we had the show. And he basically said, "Did you send me that, whatever it was?" And I took a look around and I said, "It looks like I didn't do it for you." Oops, sorry. He said, "Okay." And he
on its way.
He's apologizing to me. When he calls, he apologizes to me because he said, "I know you're very busy." And that's the truth of the matter. It's not just me. It's probably every paralegal or lawyer in Ontario is, they're how busy they are is not just to this, not just 50% busy. They're 120% busy. They're way up here, right?
Yeah, and it's very hard for us sometimes to keep up with everything. And when something new happens on your case, call us up and tell us.
Yeah.
Say, for instance, we filed against a neighbor, and then the case got served on the neighbor, and then the neighbor served us a defense.
Yeah.
But the neighbor's continuously bothering you. They put cameras up. They did something. We need to know about it. All of these new things that are going on, because these things will have to be added or brought back to the neighbor's attention. We'll be having to write a letter or to do something. Okay, so there's a lot of different things that can happen. Or if we sued for money from somebody and the party has started paying you, isn't that nice? Hey?
Yeah.
And so I said, okay, how much did they pay you? And I know that, say they owe you $15,000, but they started paying you $500, and then again $500. So that's fine. We take it off, right? So that's how we do things, So this is like, there's a lot of things like that we do. And same likewise, if something happens on your file that's at our end, we will let you know. We'll tell you that the matter has been served. The court has set a settlement conference date. And it's up to you. Do you want to meet before the settlement conference date to talk about your settlement conference and what you might want to settle for? Or hey, there are people who come to us and they say, well, I just want to take it to trial. We do try to explain to people the risks of trial, because going to trial is not always something that is going to be satisfying and rewarding, right, for some cases. Right?
Okay.
Although there are cases where I have clients who feel they have a strong enough case, and we have them sign the dotted line where we instruct them about the possibility of paying the other side's costs. We have them knowledgeable about the fact that they may lose, that the witnesses and so forth may forget everything, So
in fact, actually, witnesses forgetting something is very important when you think about a 5-year-old case. I've had 2 of them where 5 or 6-year-old cases, whereby the witness, when I've spoken to the witness in, beforehand and outside the courtroom, they're talking about, yes, I know what happened, and you run them through it, and they've told me the story. And when they get into the courtroom, they're kind of, I don't know. And then they tell another story entirely. And it's not because they're lying, it's because they've forgotten what happened.
Yeah, and there's something called a little bit of like amnesia, anxiety, that happens when you're on the stand.
Yeah.
I would sit with him for hours before his trial because he was very, very specific. And during my pre-arrangement with them, he was very clear. He had details, knowledge, and information about everything. And he was going through the pictures with me and everything else. He got on the stand. I can't remember. I can't remember.
Yeah.
And I said, "Oh my God, I have to take him out for 5 minutes and talk to him." It was just this kind of thing,
And again, in part, I guess that's because up on the stand that they're facing is a judge who sat up in a much higher position, looking down upon them, because he looks down on the entire courtroom. And of course, we generally in most lands that feed people in Canada, bring people to Canada, judges are revered as honourable people. So, and we kind of get to a point, and particularly if the judge asks a question, we go, "Woo!"
Exactly. And the guy says, "Oh my God, am I going to get in trouble?" I know. People are
Oh my God, if I don't say the right thing, I'm going to prison.
Yeah. And many people haven't been to court before,
Yeah,
so
exactly.
they have no idea of that. So we have to prepare people, so they know what to expect when they show up at court, and what to do, how to dress, that sort of thing. Have to call the judge, So it's a very there's a lot of things that are involved.
Yeah. Okay, so so we've discussed. So did we discuss this question about what was billable and not billable?
Yeah, that usually shows up in the retainer. When say if you decide to retain our firm, I give you a copy of the retainer. We go through it together, and I talk to them about what's billable, what's not, and it's written right in the retainer, like some telephone calls, postage, couriers, any kind of disbursements if I have to pay a filing fee, HST, our fees, of course, and it shows how much the fees are on an hourly basis.
Yeah.
And some things we do flat rate. So some things we say, okay, this is $1,000 flat rate, which means if you spend 2 hours or 20 hours, it's still the same. And it's flat rate.
Yeah.
So there's a lot of different things that we bill, and it's written right in the retainer to explain. And if there's disbursements, are they extra or are they not? So we try to explain to people how it is, and we answer questions.
Yeah.
So the thing is, when you have what is called the limited scope retainers, which is where I just want to have some research done because I'm handling my own case, but I have no idea how to research case law.
Yeah.
So we'll go in there, we'll research all the case law for you and give you procedural advice. And you go and just do it on your own, okay?
Yeah. All right. The next one we've got is a consultation does not establish a formal working relationship. It doesn't establish a contract. It doesn't establish anything of that nature. In order to do that, what typically happens is we will send you a retainer. If you want to retain us, you sign it and send it back. We might follow up a few days later if you haven't signed it to say, hey, we sent you the retainer. Did you get it? And, I've had a few whereby, yes, I got it. I'm actually waiting for my paycheck to come in before I can pay you. Fine, that happens, right?
To talk to you, I was just wondering if I can do it in a payment plan or something.
Yeah. Oh, so yeah.
People, they discover that, I don't have much money to pay the full retainer, but I was thinking of maybe paying half now and then 2 weeks later paying another half, or
exactly
the person's financial.
Yeah. So, in order to, just the consultation, you've got to go further than the consultation in order to get to a formal working relationship. And lawyers and paralegals, as a note, have to be clear about what their fees are and their billing methods.
Yeah. So we do up a bill, at the end of our service or at periodic parts of the service. So if you ask us to send you a bill, we'll send you a bill. And it explains exactly what we did. Okay? I wrote a letter to so-and-so. The person wrote back. We answered with another letter. I contacted the client. I put it into the calendar. Then I started working on the claim. I spent 2 hours working on the claim, an hour of research. Okay, so these things we put in, and then you kind of know what we did. Okay, so when it comes back to you, that you're not surprised. So people don't think that we did nothing.
Yeah, and honestly, for example, if we write you an email that says, that gives a list of what we've done to date, and now it says your options are A, do this, B, do that. At that point you've got to come up, which is, I suppose, the other one is C, do nothing. But again, you've got a choice point to make. And until you make the choice, we can't do anything.
Yeah, like I've got some people who are in very, very serious financial situations. Like they're getting sued by somebody, they signed guarantees, personal guarantees to the thing, all this different stuff. Like if they had been to me prior to going and signing these guarantees, I would have told them not to sign a personal guarantee. Right? To try to do whatever they can to avoid that guarantee.
Yeah. Okay. And one last point to note is, hey, you don't work for free. Don't expect your lawyer or paralegal to do so.
Yeah, exactly. We have people who think that we should be working for free. Or they say, oh, I'm not happy with the results, so therefore you got to give me my money back. Doesn't work that way.
Yeah. Yeah.
We don't promise results. We can't guarantee you results. We go out and do and use our skills to try to get what we can to work to the best of our ability. And the thing is, because we didn't get you $25,000, and it doesn't matter. We can't promise you that you're going to get $25,000. We can say that there are some cases that said $25,000, but you might not get that because.
Yeah.
It's always reasons we look at, and we're aware of the case law.
Yeah. And in Britain, there used to be kind of cases that were, for example, in a personal injury case, the value of a broken or wrongly mended arm or something of that nature. A permanent disability of the arm would have a particular value.
Almost sounds like the meat chart that they used to have for the WSIB.
Yeah, meat chart, I think, is what it was actually called at the time. Yes. So when I studied the bar, there was actually a set of cases that was the meat chart. Yes.
Yeah. But now they're looking more at a whole person perspective when you ask for them, and then you write in for that.
Yeah. All right. Well, it's been a pleasure presenting to you guys. And I hope now you understand a little bit more about consultations and why you're best off paying for your legal fees, why you need representation. I can't tell you about your particular case because we haven't been talking specifics here. We've just been talking about consultations. But if you need to contact Invictus Legal, you can do so at 905-688-5598. Angela's email is angela@weareinvictus.legal. Mine is peter@weareinvictus.legal. And the website is weareinvictus.legal. Okay?
Yep.
And
check our website once in a while because we do put different things up there all the time.
Yeah. And Angela?
Yeah, so what you heard today on Spin Legal, whether it's on this show or in others in the series, it's not legal advice. Like you can't take that to the bank, what we say on Spin Legal. You can't go in there and say, but I heard on Spin Legal, as if it's some kind of case law or something. So if you need specific legal advice and then you have a problem or you have an issue that you feel that you need to talk to a paralegal or a lawyer about, contact a paralegal or a lawyer. And then talk to them about your issue, and then you'll get something that's more tailored to your situation.
Yeah. All right. And well, it's been a pleasure having you. And I wish you a great week. And we will see you again next Tuesday at 6. Thank you.
Okay.